afternoon, Your Honors. I am Georgelina Araneta from Raleigh, North Carolina, and I have before you a case concerning the sentencing of a gentleman by Mr. Roger Camp, and basically, in our appeal, we have three sentencing issues. We have an ineffective assistance of counsel claim and a judicial participation claim. On the ineffective assistance of counsel claim, I do not need to be heard and just wish to rest on the arguments made on the briefs. I would like to start, however, with the sentencing issues. Basically, we have two issues that deal with the amount of loss, and then we have another issue that deals about with the application of a two-level enhancement concerning the use of sophisticated means. And it's my position and my client's position that the district court erred when it applied an 18-level enhancement for the amount of loss. And the gist of our argument on this is basically, according to the guidelines, the government had to present the fair market value of the collateralized property, which was real estate, which in the end was a shopping center located in Mebane, North Carolina. And they had to present the fair market value at the date of the plea of Mr. Camp, which was in April of 2012. And this was not done.
Which property are you talking about again?
Okay,
The Keystone or the,
yes, the Keystone,
Okay.
actually Key Source Bank. And so Key Source Bank had,
where in the sentence guidelines do you find that they had to present the fair market value of that?
that had to do with the application notes, application note 3.
Right?
It is subsection E, where it says credits against loss.
Subsection E2 says that where the collateral is pledged or otherwise provided, the loss amount is to be reduced by the amount the victim has recovered at the time of sentencing from the disposition of the collateral, or if the collateral has not been disposed of, the fair market value. The collateral had been disposed of at the time of sentencing, hadn't it?
Well, basically, our position is that it's
Well,
actually,
had the collateral been disposed of at the time of sentencing?
it had been disposed of, but it was purchased by the bank.
Well, there's no exception in this application note.
You're saying it's a
Except-
sham transaction or something?
Well, I'm claiming that it's application note subsection 3 that actually applies because Key Source provided a mortgage. That's what they did, and it says, notwithstanding clause 2, in the case of fraud involving a mortgage loan, if the, they go on to say that if it has not been disposed at the time of sentencing, you have to use the fair market value.
Right, that's the same note I'm looking at. If it has not been disposed of at the time of sentencing, and this had been disposed of at the
Okay.
time of sentencing,
Right.
correct?
You are correct. However, it's our position when it's the same entity that bought it back at a bankruptcy proceeding, that they still were required to present some evidence of the fair market value. And
And what's the basis for that argument?
well, it was the same, I mean, there is no legal basis on it if you're asking for a case law.
Isn't that evidence of fair market value anyway, what somebody is willing to pay for it?
Well, if it's the same bank that.
Same bank or not? Is there anything in this record to indicate anybody else wanted to pay anything for that property?
Well, as I understand, the bankruptcy.
I understand that is there any indication in the record that anybody else wanted to pay anything for that property?
I am not aware, Your Honor,
Did you
not
have
in
an
the
auction?
record. Sorry?
They had a foreclosure sale, didn't they?
Yes, they did, Your
The
Honor.
bank paid $1.5 million,
Correct.
and that's what you say is insufficient. I mean, $1.5 million is insufficient, you say, but there wasn't anybody there bidding $2 million or anything.
Well,
If
the
it-
thing
if
is-
it- If it had been worth $5 million or whatever it is you think it's worth, somebody would have showed up and offered 2 or 3 probably.
Well, part of the problem, this happened during our Great Recession, during the financial
Well, that's the
crisis.
fair market value then. At the time, everything, the bottom went out of it.
Do you have any other argument to make on loss?
The next argument that I have concerns Capital Bank. Capital Bank, basically, this was a loan of $2 million that was secured by a UCC1 filing. And again, also, in this particular case, they were required to determine the fair market value, which was not done at the time of the guilty plea in April of 2012.
Why do you say that?
Well, because there just wasn't any evidence from the government. They just went on the amount of the loan. And one of the problems that I had with the valuations of what was the property was sold for is that they were looking at values of a bankruptcy proceeding that started in 2011. And the plea was put in April of 2012. And going back through the record, we don't, there's not a date that the government relied upon.
Do you think there's any argument to be made here? I don't think you made it, but maybe I'm wrong. Between actual loss and intended loss in this case?
Well, yes, and that's another issue.
Well, make that distinction for me, and what difference does that make to your argument as for the enhancement?
Okay, well, I would say.
It may not be an enhancement, it's a number of points.
Right. The client from the very beginning has been claiming that there was no intended loss because he was, for example, for the Capital Bank loan, there were 3 guarantors. Camp was a guarantor along with.
Are you making a distinction between somebody who goes to the bank with fraudulent documents with the sole purpose or with the purpose of trying to get money and walking away with the money as
Correct.
compared to somebody who takes forged documents to get the money, but he's not intending to walk away with that money. He's intending to pay it back, but still make a big old profit and put in his pocket.
Well, I'm not sure what kind of profit they were expecting.
Well, I said, are you making the difference between those people?
Yes, that is correct,
And
Your
so
Honor.
you want to claim that the losses that he just, when he went and borrowed the money to try to do right, the economy collapsed. And he can't help that, but he never intended for a loss in those scenarios.
And that is correct, because just as evidence of this, the Key Source Bank, what they did is they paid off the previous
What do you do with
mortgage.
actual loss, though, in this case? What do you do with actual loss in this case? Can you get over 2.5 million on this record on actual loss? Isn't 2.5 the cutoff point?
It is the cutoff point, but the argument that I was making is that at sentencing, the government did not present, and again, we're saying.
Well, they presented some actual loss. Didn't the bank lose 2.3 million?
That is what they relied on, but we're saying there was, yes, you are correct.
You lost that argument, perhaps, but you have, for the purpose of my question to you, on the loss, that the bank paid 1.5 million, didn't that leave a net loss of 2.3 million?
Correct.
Okay, I understand you don't concede that point, but if it does, now what about, then don't we have actual losses in the record in addition that would add to that 2.3 million and get us to 2.5?
Well, it's our position, though, that that value was not correct because,
2.3 is not correct.
correct.
Right, but Judge Shedd saying, if that's correct, you only need $200,000 more. And then you're up there to where the government needed to be,
Right,
and you get 18 levels.
right. And so it's our position, for example, that Capital Bank, that loss should not be counted, again,
All right,
because.
if you take out the Capital Bank, then
Right.
they count the Trust Atlantic Bank.
Well, actually,
That's
those,
$500,000. That puts you up there to above the 2.5 million.
but money was not given out by Trust Atlantic Bank, and North State Bank was repaid all its money. And the pre-sentence report in Appendix 758 states that both banks sustained no losses when it was trying to come up with the restitution amounts.
What about the Timothy Buckley?
Right, with Timothy Buckley,
I'm not
What was
asking
in-
who he is, I'm just talking about
Right.
as to the losses he incurred. What about
Right.
adding his losses?
well, I would submit that he,
250,000, that puts you up there above it.
Right, but I would sustain that his actual loss was $125,000 because there were two separate loans. There was a loan for $250,000, and that was given without any fraudulent or deceitful actions. And then there was the second one where the $125,000.
So you claim that the 250 is not even related?
I'm not saying that it's not related, but
You mean, well, what are you saying then?
The
Is
judge counted that against your guy, didn't he?
he did, and we're saying that should not have been included. 'Cause
Why? Why?
Because this was supposed to be for fraud and deceit. There was no fraud or deceit in
But
getting
what about
that
what
loan.
about the entire scheme, though? What, was that money taken and used at all was that money wasn't held separate and apart to buy a vacation home or something, was it?
No, it was
It was
not.
put in this business.
Correct.
Right, okay.
And again, the whole goal of all these investments was to keep the shopping center alive and to create a viable investment, a bowling alley.
They were remodeling that bowling alley, weren't they?
Correct, and that's where the expenses actually came through, because from Key Source, they used about $1.5 million to upfit, and then the Capital Source Bank was also used for upfitting. And in the end, there was evidence in the record that the property, once these improvements had been made, was worth $5.1 million. And so my client, his position is that basically the government did not prove its position for the amount of loss with Key Source Bank because it was the same bank who bought it. And so the losses
Going
were on
back to Key
paper.
Source. Key Source is the key to your position here, is that right?
Well, I would say yes, but also with Capital Bank, the fact that it was secured and that Camp also invested about.
If you knock those two out,
400.
you got it down there, don't you? If you knock those two out. But
Well-
that's $4 million that you want to knock out of there.
I understand, but I would like to minimize the losses from Capital Bank and try to keep it out of the level 18.
Right. We understand that. You got some other points here that you need to.
Yes, that
If
is
you're not
correct.
successful on that 18, you've got the sophisticated means.
Right,
And you
and,
say that Judge Boyle strong-armed the plea.
correct.
You got
we-
some things like that, too.
Right, so basically, we have claimed that two-level enhancement was not correct because so basically, the actions consisted of forging signatures and altering documents. And there's no evidence that any of the documents presented to the banks from my client involved more than whiting out dates, recopying, scanning, or other information of existing documents that were altered. He claims this was not a sophisticated scheme. His actions were done to protect the investments that were related to the other entities. And once again, it goes back to his intent. And his intent was not to have any actual loss for anyone.
He was trying to hide the real facts from the banks, though.
I understand that, and that was done.
He pled guilty, didn't he?
He did, and that
Guilty-
goes,
Pled guilty to the entire indictment. Right?
he did, Your Honor. And
Did somebody forge his name on, or stand in for him at the plea colloquy?
actually, it was a straight-up plea, Your Honor.
Straight up.
Straight up. And that's where the final argument concerning judicial participation comes in. It's my client's position that the district court judge was involved in his plea negotiations and the questioning of the
Now, the
witnesses.
judge wasn't involved in any negotiations. What you're arguing is he made a statement from the bench about how strong the case was. After the government presented its case in chief, the judge said, "This is one of the strongest cases I've ever seen." And then the defense counsel went out and conferred with his client, and they came back in and pled guilty. How's that participating in plea negotiations?
Well-
There weren't any negotiations. He pled straight up.
Well, the point is that after the judge gave his opinion as to the strength of the government evidence, he also mentioned about perjury and obstruction of
He
justice.
did.
And so
He did.
What's wrong with that? You can't
Well-
tell, you can't tell a witness, can't you tell a witness, you're about to take the stand, I want to tell you this much, you certainly may take the stand, but if you take the stand and tell a lie, and I find it to be a lie and this perjury, I'm going to enhance you for that at sentencing. Isn't that entirely proper?
Well, my client felt that that was not proper. and he
Under the law of
felt-
this circuit, is that proper?
Well, I would say it is.
It was solid legal advice, as the judge said from the bench during the course of the proceedings after hearing the evidence.
Well, the judge would.
And seeing the evidence, a lot of this was these documents that had been falsified.
I understand, but my
But,
client.
but that's a comment on the evidence, which is proper. But are you suggesting that a judge can't say to somebody, if you don't tell the truth, you can be charged with obstruction of justice or perjury? The judge can't say the truth in the courtroom?
But he didn't word it like that, and so my client felt
says it-
intimidated.
Says you know what happens in court, but perjury is a specter and obstruction of justice or whatever. The import of that is you better not lie and obstruct justice. Isn't that what it is?
Well, that's not how my client
What
interpreted
did
it,
your client
Your
take
Honor.
that as?
Well, basically, he took it as that the judge was, in his words, he felt that the district court judge was impartial throughout the trial. He felt that he was abusive, prejudicial, coercive, and determined to
Now, that's
participate.
that's your argument.
Well, this is,
That doesn't show up from the record as to what he felt because he didn't testify.
right, but this is how my client interpreted the judge's
That's
actions.
what he's saying now. But you weren't the counsel, right?
Correct, I
And
was
that's
not
why
the
you say,
counsel.
and you say the counsel was,
The lawyer then was ineffective constitutionally, right there on the spot, which you haven't argued much today, but for letting him plead guilty,
Well, it was more with the sentencing about.
or the way he dealt with the sentencing, he was ineffective. That, and you say that jumps right off the page. You got any other issues you haven't raised?
Well, my time is up, but just very quickly,
Right, you got that red light on.
Yes.
And you've got some other time, too. You saved another few more minutes.
okay, and basically, separate and apart from the plea negotiations, he felt the judge engaged in judicial participation in the question
Why
of
isn't
all
all
the
that way
witnesses.
by the
That's,
guilty?
but that's wrapped up by the plea. You're not going, well,
Okay, all right.
you pled guilty, as if the trial, to the extent it went on, is wiped away. I mean, you plead guilty. He came in and he pled straight up to the entire indictment. And there was no plea agreement.
Right. My client, in the end, would like a new trial.
Right. He'd like
And-
a new trial. He wants to get out of it. He'd have to, but you don't even ask us to set aside the plea. You're arguing, maybe you do.
Well,
but inferentially.
I am, just because of the judicial participation, and then basically, also, if that will not be granted, a resentencing, to allow him to introduce, or have the government introduce the fair market value.
Okay, let us see what the government has to say about this, and you have a few minutes left. Ms. Fritz?
Yes, thank you, Your Honor.
Were you the prosecutor?
I was not the prosecutor. May it please?
We don't have anybody here that was in the court proceedings today.
No, you do not. That being said, this case is about a sophisticated businessman who induced financial institutions to loan him money by overstating his own assets and by exploiting the success and reputation of his good friend, Mr. Buckley. The defendant may have deceived these banks, but the district court was not so easily fooled. The court correctly calculated the loss, enhanced for sophisticated means, calculated restitution.
Where's the loss? Where's the actual loss of, can you point to actual loss of 2.5 million?
Yes.
All right, where's that?
First of all, you have the $2.3 million loss
With
from
you on that.
KeySource.
Yeah,
Okay.
okay.
Now, the Capital Bank loan was for $200 million. It was secured by business
$2 million.
chattels. $2 million. Yes.
You said 200 million.
Oh, I'm sorry. $2 million. It was secured by the business chattel, the bowling pins, the restaurant equipment. Now, importantly, the bank did not perceive this loan as being fully collateralized by those items of business chattel. That's precisely why the defendant needed to fabricate Buckley's guarantee. Although at sentencing there was not specific evidence provided about the value of the business chattels, during the trial, one of the witnesses, Hostetler, on pages 177 through 178 of the record, he says, quote, "The collateral was mostly negligible. That's not to say it wasn't available and wasn't a real asset, but the secondary market, if a bank were to take bowling pins and bowling balls and chairs and tables and food inventory and try to resell it on the secondary market, it would bring virtually no value to the bank." So I would submit to you that there is no conceivable way that that loan would have resulted in less than $200,000 worth of loss.
Because you're doing that by taking the amount of the loss and subtracting zero, the amount of the loan and subtracting zero from it?
I am saying that the collateral is a real asset, but it's negligible.
Kind of shouting a little bit out.
Oh, I'm sorry. It's negligible in comparison to the,
I thought you said that it would be zero. Did he say that, or what did he say, negligible, or what did he just say?
he said that the value of the collateral was negligible.
Right. So your point is, you assigning zero or something to that?
You'd give him $200,000 today, you're giving him more than you gave him at sentencing.
I think that based upon the information available at sentencing, the bankruptcy trustee estimated that there was about 1.9 million outstanding on that loan.
But is that an actual loss in the terms of the guidelines, or is that, do you see a distinction between the scenarios I set up, what, an actual loss and an intended loss? Let's look at intended. And we have a scheme under which a person just tries to bilk a bank. They just go into with forged documents, they say it's a check from you, and they take $2 million.
Okay.
Versus going in and trying to set up with fraudulent documents to get financing that they believe will turn into a profit, they can pay back the loan. There's no intended loss in the second scenario, is there? There may be actual loss, but is there any intended loss? He doesn't intend for the bank to lose the money. He intends for the bank to be repaid with his ongoing business, doesn't he?
The defendant may have intended.
Well, then it wouldn't be an intended, but how does he get hit with an intended, the burden's on the government on the amount of loss, right?
Yes.
Do you see a distinction between those two kinds of losses? An intended loss where the person is trying to rob money from the bank or steal it from the bank, and one where he just is not a good businessman and he ends up not, or the economy goes bad and but he never intended for it to be a loss. He intended for it to be an ongoing business, to repay the loan and to make money himself. That's not part of his criminal activity as far as a loss is counted against him, is it?
I think it would be, because that would be reasonably foreseeable pecuniary harm. The
No, it wouldn't be, not if he thought under the conditions, what if, I'm just gonna say, we'll move on. He goes in a good economy, he does forge a document, because he's trying to build his empire, and he gets a $2 million loan. And from all of his projections from his accountant at that point, he can make $8 million on the project. Then the economy goes south, and he loses everything, including that $2 million loan to him. That's not an intended loss. That's not a foreseeable pecuniary loss. That's just, the economy caught up with him. Why would that be an intended loss under his scheme?
Well, I think that some of the factual premises in your question are.
That was my hypothetical to point the difference to that. though.
Okay. In this case, however, the economy was going down when he was making
So,
these
okay, so take my
negotiations.
hypothetical, he thought he was smart enough to beat the economy, and he had something that would sell. That may be bad judgment, it could be stupid, but why is that a fraud loss? Because he didn't, the guideline says actual loss or intended loss. What would that? It says intended loss means the pecuniary harm that was intended to result from the offense. Is there any evidence that he intended to take that money and put it in his pocket and not try to salvage his company? There's not any evidence of that, is there?
Not with respect to Capital Bank. It is
With
pretty.
what else is there?
I think that, for example, if you look at Trust Atlantic, he was in the process of negotiating $500,000 of a loan there, and he fraudulently presented Buckley as a guarantor
Did he get the money?
He did not get the money, but he intended
To do what with it?
hopefully save this sinking ship.
He didn't intend for that to be a loss, did he?
Under the circumstances where he knows that his cash flow is in bad shape, he knows that he's not meeting
But that's
obligations.
you're just dinging him for bad judgment.
No, I'm,
Well, let me ask you this much. Can you find it in actual losses? What about Timothy? What do we do with Timothy Buckley on that? Look at that personal loan for $250,000. What do you do about that?
the loans to Timothy Buckley are also actual losses. So, I mean, if you look at
But
the,
did he get back some collateral or some interest in an ongoing operation or something at that time for that note?
it is not clear with respect to the $250,000 whether there
Well, if
was an
it's not-
exchange of any collateral.
If it-
With the $125,000 loan that was later issued, I believe that in that case, Buckley requested that there be an assignment of the defendant's, or a pledge of collateral of the defendant's interest in PCI. I am not aware of the record supporting there being any collateral for the
How would that- Tell me
$250,000.
that loan from Buckley, I don't understand, how'd you get to the $250,000 actual loss number? I just can't find it, I read it, but I can't find it in the pre-sentence report right now. I thought that was collateralized at some point, but the value, am I wrong about that?
Actually,
I don't-
I retake that. I take that back. You are correct, Your Honor. Page 444 of the JA, the $250,000 was to be secured by collateral in PCI.
Right, and how much is that collateral worth now?
I am uncertain.
Let me ask that.
It was,
How can he be dinged with $250,000 if the government doesn't know the value of the collateral? Because it isn't actual loss, the amount put in less the amount retained? And isn't that burden on the government?
yes, it is.
And where do you meet that burden on that $250,000 here?
At that time, the collateral was in bankruptcy proceedings, and the exact value of what the defendant's percentage interest in PCI is
unknown,
not
wasn't
clear. But the bottom line for purposes of the loss calculation is that the court is only required to make a reasonable estimation of loss. And the reasonable estimation of loss from this scheme is over the $2.5 million mark.
No, I've got, listen, I'm just gonna ask you one, I see the 2.3, I think it makes sense to me, and I'm trying to find, see that 150 loan, North State loan, and the 125 loan that won't get you there. I'm looking at that 255 and I'm 250,000 because that'll get you over on actual loss. And I'm trying to figure out how do we value that $250,000? It appears to me the state of the record is he loaned $250,000 that was collateralized, and the collateral was worth something, but we don't know how much. How's that not just speculation? Because you have to get $200,000 loss out of that, don't you?
Again, I would suggest that the district court is charged with making a reasonable estimation of the loss, and
Yeah,
that
but-
property is in the bankruptcy estate.
But that doesn't-
And at that
doesn't
time,
mean it's not worth something.
at that time, Mr. Buckley had not received a dime of his money back. To the
But that doesn't
extent,
make it, but that the burden's on you to value that. You just can't go in there and say, Exxon Oil's in bankruptcy, so your stock's worth zero. It may be a restructuring. You may have assets that, people may get paid out of bankruptcy. I just don't see how you put the lack of the government, maybe you showed it somewhere, but you haven't told me and I couldn't find it. How do you put the lack of the government coming forward and meeting their burden? How does that fall on the defendant?
I think that, again, if you look at the scheme, it was clearly over $2.5 million. In this case, the government presented ample evidence to support a finding of loss exceeding that. And I would note that with respect to Mr. Buckley, who's primarily raised in the restitution component of the defendant's argument, the defendant did not argue or did not object to that restitution amount.
He objected to the calculations for the losses, though. I
Didn't
looked at,
object to the restitution?
He did not object to the
Doesn't
restitution.
raise that on appeal?
He does raise that on appeal.
So that's plain error review?
Yes, and he cannot meat that.
it's not plain, may I say something? It's not plain error review if his objections to the findings on losses, fairly takes into account the restitution award, doesn't it? Because the restitution award is based on the loss calculations, isn't it?
No, I would
it doesn't?
disagree. The loss calculations, the way the guidelines are written.
How do you get to restitution if you don't figure out how much you've lost?
Well, I think that because of how the loss.
Just asking, that's not possible, is it? You don't know how much you have to give in restitution unless you first calculate how much that person has lost. Isn't that correct?
Yes,
Okay.
but the guideline talks in terms of actual loss or intended loss, and it instructs the court to take into account the greater of the two. So there may very well be a case where the loss is counted, such as in Trust Atlantic, where there is a $500,000 loss. Now, Trust Atlantic never loaned that money out, so while there is a loss for purpose of the guidelines loss calculation, Trust Atlantic is certainly not owned restitution.
Where do we know that the court took into account the very question I asked you about intended loss? What does intended loss in the guideline mean? Was that even discussed? Intended loss? To make the distinction that I'm asking you?
I don't believe that there was such a discussion. I think the court had sat through the trial, was familiar with the evidence, and was comfortable with saying that under
Court
these
still has to
circumstances.
do the proper calculations on losses
Yes,
under the guidelines. I interrupted you.
and the court did make a reasonable calculation here.
Now,
And
was Mr. Buckley, did he the one that complained on this fella, turned him in?
actually, my understanding of the record is that Trust Atlantic notified the Raleigh Police Department.
That's how they caught him?
Yes,
But
well,
Buckley's deemed a victim here, and he gets restitution.
yes.
On some of this evidence, looked like Buckley was right in the middle of it, didn't it? He's falsifying documents and.
Absolutely not. Buckley,
He was transferring interest that he didn't own and taking interest that he didn't buy and things like that.
if you're talking about the 24% interest that was transferred,
Right.
that was the defendant's idea.
Was his idea, but this fella signed the papers
Well, the
and
defendant,
signed them back after they made the loan.
no, the defendant transferred the 24% to him, and the defendant's purported rationale was that the defendant did not want to be both the lessee and the lessor. So by transferring the 24% over to Buckley, he could sign on behalf of FEC. Buckley had made very clear that he was not interested in investing in FEC. And once that had transpired, Buckley did sign that back to him, and Buckley absolutely signed the lease on behalf of SEC. Buckley did not sign a guarantee on behalf of FEC to guarantee the rental. That was forged and altered.
Well, several times it was they forged his name, right?
Oh, many times. He forged his names, he falsified financial records that purported to be Buckley's. And what was interesting about the financial records is the defendant drew on his knowledge of being Buckley's friend for over a decade and mixed truth with fiction. He knew where Buckley had certain properties. He would falsify the value of those properties, say that they were paid off. He knew where Buckley had a number of his assets, and again, he would overstate those. The evidence at trial showed that Buckley was not aware of this fraud or his reputation, his good name being used until February 2011 when that letter arrived at his house. And then he promptly followed up, and that was from Capital Bank. And what's interesting is he also had some qualms about KeySource Bank, and when he first called the PCI attorney about that, he asked, am I in any way a guarantor on this Key Bank thing? And the PCI attorney looked at the closing documents and said, no, you're not. And that, again, that goes to the sophisticated means. The defendant had structured the transaction. It was his idea how to structure the transaction, where Buckley was a guarantor of rents to FEC, and then that was reassigned over to the lender. So the lender had all of Buckley's information that had been provided by
What
the
do you make of
defendant.
the court asking too many questions or pressuring the defendant to plead guilty?
I think that is a,
Let's take it one at a time. What do you think about the judge asking too many questions? What do you think about that? Your response is what?
the judge asked clarification
Is
questions.
that waived? Is that argument waived by the guilty plea?
Yes, I would suggest that it is. It is waived by the guilty plea, and a court does have the prerogative to oversee the method and mode of how information comes in.
What do you make with those comments at the conclusion of the government's case, the comments by the judge at the conclusion of the government's case?
Those, well, first of all, there was no plea negotiation. This was, at the close of the government's case, outside of the presence of the jury, the court asked the defendant, do you want to go forward with this trial? The court is entirely within its discretion to give the defendant some time to think over, having seen the government's case, what the government wanted
Well,
to
the argument
what the
is not
defendant
that the
wanted to do.
court said, do you want to plead, do you want to think about it? That's not what the argument is, it? Isn't it, you never know what happens in court with perjury as a specter and obstruction of justice and whatever. I've tried a few cases, and I can only remember one other one, I won't go into it, where something like the evidence that just came out, came out. That's not just saying think about it, is it? What about those comments?
Those comments, the reference to the prior case in perjury, I think it's essentially the court suggesting that the defendant proceed with caution. The defendant is listed as a witness on his own witness list. The defendant's opening statement suggested that he was going to take the stand and tell his side of the story. The court was aware that the defendant had already provided testimony in the bankruptcy
I know the
case.
context of it. I'm asking you about what do we do with the legal, what's the legal significance, if any, of those comments by the judge?
There's nothing wrong with those comments by the judge. It was, as Judge King stated, it was sound legal advice. Take a moment to think about this. And the defendant came back, and he decided to plead guilty. And the defendant was asked during the Rule 11 plea, are you sure? Are you under any pressure? And the defendant's response at one point is, I'm cooked in this trial. The defendant acknowledged, he saw the evidence against him, and he made the informed decision to plead guilty. And in fact, although the PSR had initially not awarded him acceptance of responsibility, he strongly argued in his objections that because he had come forward and pleaded guilty, he should receive the benefit of that. There's nothing that suggests that this is an involuntary or coerced guilty plea. Now, with respect to sophisticated means, I would like to point out one or two other ways in which this was sophisticated beyond just the forging of the document. And I mentioned before the transfer with the 24% interest.
If we think the loss number is not in the record, what would you propose we do? If the justification for the 18 points because of the amount of the loss not in the record, what do you suggest we do? Remand it for further consideration on the record as it existed to make those arguments, or what do we do? Do you get another bite at the apple?
If the court were to find that the loss was not supported, which,
Let me guess, you don't agree with.
no, we don't agree with that, then it would, I guess the remedy would be to remand, unless, of course, the court is confident after having reviewed the transcript that the district court would have imposed this same sentence. The court did not make reference to having imposed an alternative sentence, but he did make the court did, throughout the sentencing hearing, make a number of comments which suggest that this was the sentence.
Do you think there's any argument to be made by the government that the government was in the process of charting out all the losses, and the district court basically cut you off and just sort of said what he agreed the number was?
Yes.
Did that
I
happen?
think that you could make that argument because the court, we were in the process of setting forth the evidence, and the court says, look, I'm satisfied. We only need to get to 2.5, right? And then, so to the extent that there would be a remand, we should be permitted to.
Because you say you in the process of charting it out, the government just the court from its own involvement knew the numbers and said, that's enough, you've established it.
Yes.
Okay.
If may I have a moment to make a closing statement?
Your red light's on.
Okay.
You've covered about everything.
Thank you very much. I ask that you affirm the judgment of the district court.
Thank you. There you got a closing statement.
He got one.
Ms. Fritz, we appreciate it. And Ms. Araneda?
Thank you, Your Honors. I will be very brief. Going back to the total amount of loss, 2B 1.1, in the section about credits against loss, I'm going to reiterate my position that I really do not believe that the way this is worded, that when it's the same entity that is sustaining the loss and is rebuying the loss, I believe it was not meant to, this wording about what was the amount of disposition of the collateral, I think we need to make a distinction in that the victim, for example, in subsection 2, they say the victim recovered at the time of sentencing from disposition of the collateral, where the victim was KeySource Bank. At the same time, KeySource Bank was also the buyer of the collateral. KeySource Bank, we do not know if they were still the owner at the time of the sentencing. So if it's still the same party, so I guess what I'm saying, if it's the victim and the victim is still the owner of the property, I think it's just too early to tell the amount of loss.
Do you think in rebuttal, that's the very strongest point you have to make in rebuttal? That's what you think is your strongest point in rebuttal?
Well-
Is to go back to the first point you argued in the case?
I was just going to very briefly, the other point what I was going to make had to do with Capital Loan Bank and the bank official Hostetler, when he said, why would a bank, he was talking about that the UCC filing had no value. Well, my question would be, well, why would a bank do a UCC filing if it has no value? They don't just go through these exercises and they executed a security agreement. So basically what I ask is for a resentencing remand as to the amount of loss. Thank you.
Thank you very much. And we appreciate your efforts, Ms. Aranada. You're also court-appointed, and we appreciate you taking it on and helping us out with this case. Thank you very much.